Sir, itay nabit kat in archive dito iti Muntinlupa Trial Court Branch 206 dito yung murder case na naisampa laban kina dating Bucor Chief Gerald Bantag at Ricardo Zulueta. Sir, maaari ba nating ipaliwanag, sir, ano ba ang ibig sabihin nitong archive na to at bakit po na archive, sir, attorney?
Okay. Di kahit nasa unti archive kat in parlance, in layman's parlance, kat kasla nga idulin mo nya, you archive it, it's like you keep it. Gamin dagito yung courts kat they have existing dockets. What are these dockets? These are active cases that are going to be heard by the courts. So no nakadakit iti case kahit nasa un, it will be heard by the court kahit nasa un nga agpresentar iti ebidensya dagitoy accused or the prosecution and the accused. Now since hanga natiliw the way by which the court can acquire jurisdiction over the person of an accused is no ag-surrender isuna or if they arrest him, no ma-acquire na iti jurisdiction over his person, then that's the time nga ag-hearing then. But if the court cannot acquire jurisdiction over the person of the accused, then hanga mabalin nga ag-hearing, ta simpre awan mo't iti hearing because one of the rights of an accused is the right to confront the evidences or the witnesses against him and to be present at the trial at all stages of the trial unless there is a waiver. Dito ikat hanga naka-acquire pa iti court the jurisdiction kani General Bantag kani Mr. Zulueta kahanda nga natiliw. So a trial will only commence after the accused is arraigned nga kuna tayo di maganda no guilty or not guilty. Tatano handa nga maarin, then there is no effective trial that can be had. It cannot also be awan nga hamot nga mabaling nga karon iti trial in absentia nga kuna tayo. What is this trial in absentia? The trial in absentia kat bistaan da di kaso ganda di ebidensya laban di akusado uray awan di akusado. Ngam ti prerequisite na before there can be a trial in absentia kat the court must have acquired jurisdiction over the person of the accused. And how will the court acquire jurisdiction over the person of accused? By having him arrested kan dapat ma-arraign isuna. In all instances of criminal prosecution in criminal cases, masapul nga ma-arraign the accused before there can be a trial. Kat in the case ni General Bantag kan Mr. Zulueta, the court never acquired jurisdiction over them ta handa pa nga natiliw, handa pa nga nag-surrender, handa pa nga na-arraign. Yeah? They had not been asked whether they are ganda pa lang di kaso. That's what we call archiving. Nang namatiliw dan, the court will already acquire jurisdiction over their person, ma-revive daytan, ma-hearing. Okay? So that is what is meant by archiving of cases. So, hanga mabaling nga ag-proceed iti trial because the court never acquired jurisdiction over the person of General Bantag and Mr. Zulueta and they had never been arraigned. That's why sa tap na hanga makplug the court dockets, i-archive da, idulin da, kaslang paturugan da until after jurisdiction is acquired over the person of both accused. Grounds for the archiving of criminal cases kat di jay no hanga matiliw di accused. If the accused is a fugitive from justice and the court has not yet acquired jurisdiction over his person, it may be archived. Taawan mo't lang iti salbi na gamin nga bistaan dangay nga awan iti plea whether he's guilty or not guilty. The trial will be null and void without an arraignment because that is always the starting point of criminal cases. Ado pa iti grounds for archiving of cases nga it applies only to civil cases. No kas pangarigan kwarta ti pagtutungtungan tayo, no kas pangarigan there is a possibility nga ag-settle dagiti parties or if the parties are members of the same family kat there is a possibility nga agareglo da kat ag-agree na nga duwa, mabaling nga i-archive DJ case. But in criminal cases, the only ground when it can be archived is that if the accused is a fugitive from justice and the court has not acquired jurisdiction over his person. Okay? At the administrative circular nga in-issue the Supreme Court on that matter. Okay, Bombo?
Yes po, attorney. Sir, niya, kat da General Bantag ni Mr. Zulueta, kat meron na po silang patong sa ulo kung saan, kung any individual na makapagbibigay po ng information kung saan sila nagtatago or iti ayan na gitoy, makipahit informasyon kat may payan na reward. Sir, yung warrant of arrest, ito po ba ay ibig sabihin po ba ay ito na ay nagpapatunay na guilty sina Mr. Zulueta at General Bantag?
Oh no, let me first correct you on that statement. No, it's not the Department of Justice that issues the warrant of arrest, because the Department of Justice function is only to determine the existence of probable cause. Iti ag-issue iti arrest warrant of arrest kat di korte, no? So if the prosecution or the Department of Justice finds probable cause against an accused, agi-file that information di court. And based on that information, the judge will also determine whether there is a probable cause to issue a warrant of arrest. Ma-determine the court nga that the probable cause for the issuance of warrant of arrest, agi-issue di judge iti warrant of arrest, isu di iti may enforce tap na matiliw di akusado. Okay. Now, the issuance of the warrant of arrest does not mean nga they are already guilty, no? Because if that will be the case, then there will be a denial of due process. Medyo pa nag-arrest da kadagay di accused is merely preventive in nature. Masapol nga they should be brought to the jurisdiction of the court iso nga matiliw da. At dadagi offenses nga nukas pangarigan the guilt is not strong na, or at dadagi bailable offense nga kung kunatayo, mabalindang ag-post di bail. Ngam nukas pangarigan capital offenses kasla dati offense ni General Bantag for which and ZULUETA for which they are being accused. It's a capital offense, and if the evidence of guilt is strong, awan itipil na, they will be held under detention pending the trial of the case until its final termination. Okay? So the issuance of the warrant of arrest does not mean nga guilty dan. Okay? It's only a part of the criminal process in order to apprehend them and bring them to the bar of justice so that the court can acquire jurisdiction over their person.
And sir, during our interviews sa mga legal officer ng ni General Bantag at Mr. ZULUETA, sabi nila po magpa-file sila ng petition for certiorari. Ano naman po itong petition for certiorari na to, attorney?
Okay. Ang petition for certiorari is a special civil action nga i-file mo iti Court of Appeals or a higher court than the body that issues is no at the grave abuse of discretion. Yeah? No kas pangarigan dagiti gamin fiscal kat the Department of Justice is tasked by law to determine the existence of probable cause. What is probable cause? Iti probable cause is a cause that will make a reasonable man believe that there is sufficient evidence to hold a person for trial, and probably there is sufficient evidence to hold him guilty. All probability dito isang ako na nga probable cause na kas pangarigan ti fiscal, yung Department of Justice kat awanti ebidensya niya, there is no evidence, clearly there is no evidence, and yet nag-file dalata iti criminal case for murder or whatever crime nga kayat na niya kat awan iti basihan na, that is grave abuse of discretion. Because under the law, masapol nga every action that is to be undertaken by a body that is exercising a discretionary authority must be within the bounds of its authority. Tatano, if it goes beyond the bounds of its authority, nag-exceed iso na ti authority na, there is grave abuse of discretion. So no, there is grave abuse of discretion and it is motivated by hostility, hatred, no, or rancor nga kunada. Mabalin nga question ng tata daytoy action, daytoy nga body in a higher court which we call certiorari, no? The certiorari it's a special civil action that is instituted when a body or a person exercising discretionary authority goes beyond his jurisdiction or acts with grave abuse of discretion. So tikat na dito certiorari, no? May mga procedural requirements you can avail of that remedy, ano? Kasi provided for under the rules of court na before you can avail of the remedy of certiorari, the requirement that you must not have any other plain, speedy, or adequate remedy in the ordinary course of law. So halimbawa, yung resolution ng Department of Justice, you can elevate it halimbawa to the Secretary of Justice or you can elevate it to another administrative body. Han mo mabaling nga i-avail the petition for certiorari, no? So tika sa uwan nga ikat, that is your final remedy no talaga nga awanan iti mabaling nga sarako mo nga remedy, then that's the only time you can avail of the petition for certiorari. Let me give you an example, no? Halimbawa, doon sa court, if it's already filed in court, no? DJ information. And you can still file for a petition for or a motion for investigation or a motion for reconsideration of the resolution. Haka mabaling ag-file immediately for petition for certiorari because you still have a plain, speedy, and adequate remedy in the ordinary course of law. What will happen if you're going to file a petition for certiorari despite the fact that you still have another remedy that is available under the ordinary course of law? Dismissan daytoy iti Court of Appeals or Supreme Court, no? Unless it involves a noble question, di ba, question, and it is something that will enrich jurisprudence, then they will entertain it. But generally, they will not if you have any further remedy. And one more thing, you must establish that there is really grave abuse of discretion, which is very difficult to do, no? So those are the twin remedies. One is, you must establish that the court that rendered the resolution that you are questioning by means of certiorari acted beyond its authority, such that its action is beyond its jurisdiction. And number two is, there must be no plain, speedy, and adequate remedy in the ordinary course of law except that a petition for certiorari. Extraordinary remedy gamin dayta nga remedy. Okay?
Yes po, attorney. So, noong una pa no ay talagang dito ni side or yung ating legal officers ng or the General Bantag mismo at they feel na merong itong hindi patas na pag-investigate on the part of the Department of Justice kung saan ay sabi nila nagpe-prejudge itong ating secretary. Ano naman ang side nyo with regard sa ating justice system? Gapoy tinating case, sir.
You know, I personally know the lawyers of General Bantag and Mr. ZULUETA, and by chance nagkita kami mo di corridor kat pagsasawan mi mat, no? But it's their call. They are good lawyers, they are excellent lawyers, and they know what they're doing. I commensurate with their predicament. High profile case dito niya. This is a very high profile case, and it is already invested with some sort of political color. Nagrigat garod dito niya. So siyempre, bagbagada siguro nga it was prejudged because the eyes of the nation is on this case. Everybody is keeping track of this case, especially also here in here in the Cordillera. Amu tayo mat, kailian tayo ni General Bantag niya. And amu mat siguro the Department of Justice, no kanino ti simpatya tayo. But the thing is, we have to make the presumption impartial dagito there had been instances nga nag-file da pa iti motion for inhibition the Department of Justice nga ialis da lang kano the Office of the Ombudsman lang nga it was denied. But we have to rely as legal officers under the presumption of the law that official functions have been regularly performed. No? So I will not comment whether there was bias or not. What I can say is it's a highly publicized case, no? Then everybody is keeping a keen eye on the outcome of this case, and probably some people have already prejudged it, but in the end, the accused and all other parties concerned are entitled to due process. Isumat iti system of justice tayo. Yeah? Okay, so with respect to the conclusion being made by the lawyers involved, it's their conclusion. It's their conclusion. Maybe it's their personal opinion. Siyempre, mumatan, if you are on the side of one, then adamo di personal opinion mo. If you are on the side of the other, you also have your personal opinion. But in the end, it is the judge who will decide whether there was bias or prejudice.